Good morning, good afternoon, good evening, depending on where you are for this third session of this online conference set organized by the Constitutional Center, the Center for Constitutional Studies, and organized with the participation of the Leiden University. This is a set of conferences regarding children's access to justice in practice in the context of the optional protocol to the Convention on the Rights of the Child on a Communications Procedure, OP3. Today, the focus will be on addressing some ramifications and impacts that the implementation of this protocol has had, this OP3, this system for reporting before the Committee of the Rights of the Child in the framework of immigrant children or in the context of international mobility. So I would like to start saying we are sorry that Dr. Liefaard was not able to join us today. So I will be moderating the session on behalf of Leiden and the Constitutional Studies Center. I would also like to tell you that we have two panelists. We are so happy to have them both here as presenters. So we'll introduce ourselves, or I will introduce them, and then I'll tell you how the seminar will work. First of all, we have Dr. Sriprapha Petcharamesree. She is an advisor, senior advisor at the Institute of Human Rights and Studies on Peace at the Mahidol University in Thailand. She has concentrated her research and her professional knowledge in the realm of human rights with a strong focus on the work developed by nations part of the Asean, and she has experience in immigration issues, human rights, and she has experience in international affairs. She was appointed by the Thai government as the Thai representative before the Human Rights Commission in Asean, where she served at that position since October 2009 to December 2012. She has also developed a vast research, and she's well known for her work on the rights of the child, especially the rights of the child in a context of mobility. She's done so for many years. In addition to her academician works, she is co-chair of the working the Committee on Mechanisms for Human Rights in Asean, where she promotes the establishment of an effective control and effective use of human rights protection mechanism in Asian Southeast. Then we'll have Professor Pablo Ceriani. He is a lawyer from the University of Buenos Aires. He has a PhD degree by University of Valencia. He has studies from the European University in Madrid. He's director of the specialized program on human rights asylum in Universidad Lanús in Argentina. He was member of the Committee of Rights of Immigrant Workers and their families between 2014 and 2017. And he has again started as member of the committee in a new period between 2022 and 2025. He was co-chair of the Committee of Immigrant Workers and their families and of the working group that developed the general observations on children in the context of immigration. Pablo has also been a consultant for UNICEF, for the Latin American Regional Office in Spain, and in initiatives linked to immigrant children. He is a professor in Universidad Lanús, Universidad San Martín, Universidad de Buenos Aires, and in the Bolivia's Simón Bolívar University. Pablo has sent us his presentation. You'll watch a video. He has issues with his Wi-Fi connection. So we wanted to make sure to get his presentation so we could present it, but he won't be connected live. We wanted to avoid connectivity problems during this presentation. We wanted to make sure that you were able to follow him without any problems. So after these introductions, first we'll have Professor Sriprapha, Petcharamesree, for about 30 minutes. Then we'll have the participation of Professor Pablo Ceriani, and then we'll open the floor for comments and questions. So if you have any comments or questions, go ahead, use the chat box on Zoom, and we'll take as many questions as possible, and we'll give the opportunity to Professor Petcharamesree to answer your questions. Without further ado, I would like to hand it over to Professor Petcharamesree. She will deliver her presentation today. Thank you so much.
Thank you so much, Nicolás. Can you hear me well? Okay. I hope everybody hear me. Good evening from Bangkok. It's almost 11 p.m. Bangkok time. Good morning and good afternoon. I would like to thank organizers for having me to join this online conference. You can see from the first slide, which I, of course, put the title of my presentation, which was actually assigned by the organizers, that I'll be talking about standard setting under optional protocol 3, which is about individual communications, trends and ramifications for migrant children. And I would like to share with you my outlines and scope of the presentation. If you could go to the next slide, please. Next slide, please. Yeah. Okay. This is what I'm going to present to you. First of all, the scope. Since I'm sitting here in Bangkok, Thailand, and working mostly on ASEAN and South Asia. So the scope of my presentation would be focusing on ASEAN, South Asia. So I'll be first of all sharing with you the background of children on the move in ASEAN, South Asia. Then after that, looking very briefly, really briefly, on the status of optional protocol 3 to CRC in ASEAN and in Asia. Not that many countries have ratified optional protocol. The next section would be looking at the existing human rights standards in ASEAN and South Asia before looking at trends and ramifications. I'll be concluding by arguing with what Dina Shelton said some years ago. So that's really the outlines of my presentation, and I was sharing with Nicolás, our moderator, already that I would not be exceeding 30 minutes. So the background of children on the move in ASEAN, South Asia. As you can see from the slide, that of course, in the world, you have millions of children who are affected by migration globally. And most of them, millions of migrant children continue to face risk. And of course, there are many risks that they are facing. We are not discussing about the risks, but more about how, risks are addressed and how the complaints are addressed. In Asia, 2 out of 5 international child migrants were born in this region in Asia. And I am talking about Asian-wide here, not just ASEAN. In 2019, Asian countries host some 11 million migrant children or child migrants, including refugees, and about 11% of the region's total population of migrants are and refugees. So you can see that the statistic is quite important. And I got this latest statistic from Save the Children. In ASEAN alone, when I talk about ASEAN, I refer to Association of Southeast Asian Association of Southeast Asian Nations, which include 10 countries, including Thailand. In Southeast Asia, there are 11 countries, including Timor-Leste. But Timor-Leste is not yet full member of ASEAN yet. So you can see that I am talking about ASEAN and Southeast Asia here. So in 2019, there were 1.4 million child migrants recorded in the region, and an estimated of 200 to 400,000 Myanmar children live in Thailand alone. And, of course, 1.5 million Myanmar children are affected by migration between the two countries. And by the two countries, I'm talking about Thailand and Myanmar. And I guess most, if not all of you, know about what has been happening in Myanmar since 1st February 2021. It has been almost a year already after coup d'etat. And of course, with coup d'etat, violence has been going on. And people, especially those living along the Thai-Myanmar border, have been trying to cross the border into Thailand. Among them, actually more than half of them are women and children. In 2019, around over 700,000 refugees from ASEAN countries were children. And you also found natural disaster led to 1.8 million internal displaced persons of children in 2019 alone. So when we talk about migrant children, we are not just talking about those crossing international borders, but also those having been displaced or having displaced within their own country as well. Just want to put a note here that ASEAN region, as I said, composed of 10 countries, encompasses countries of origin, transit, destination, and combination of origin and destination with internal and cross-border migration, as I just mentioned to you earlier. Next slide, please. So as I said, I'll be showing or discussing briefly about the status of Optional Protocol 3 to CRC in ASEAN and Asia this time. I'm globally, I just checked a few days ago, 2 days ago, that globally there are 52 signatories of the Optional Protocol 3, and only 48 countries are parties to the Optional Protocol 3 on individual communications. And as I put the status dates back to 2 days ago, 16 January 2022. If we look into detail, only 3 countries from Asia ratify Optional Protocol 3, and these 3 countries include Maldives, Mongolia, and Thailand. So in South Asia, only Thailand is party to Optional Protocol 3 to CRC. And Thailand is the first from Asia to have ratified Optional Protocol 3. So Thailand was among the 10 first 10 countries having sign and ratify Optional Protocol 3. So we can see here that we see a rather slow ratifications internationally and regionally. Next slide, please. Next slide, please. When we talk about protection risk, I talk about risk of migrant children in ASEAN, South Asia. Protection risks include child immigration detention. Many children, I do not have exact statistics in South Asia, but you have countries, for example, Malaysia, which put children, migrant children in detention. Thailand was doing so until recently. Apart on top of child immigration detention, children on the move also face the risk of lack of protection for refugees and asylum seeking children, including unaccompanied and separate children, or children who are stateless or at risk of statelessness, and children of migrant workers. I just want to mention here that out of 10 countries, 10 ASEAN member states, only Cambodia and the Philippines are parties to 1951 refugee conventions. Thailand is not party to it. Discrimination in access to basic services is another risk that we record or we found in every single country, including Thailand. Exploitation by smugglers and traffickers, especially I mentioned about the current situation in Myanmar. So children, women and children are actually currently at risk of smuggling and trafficking. And of course, we see as well the sales of children and the lack, one of the problems in this region is the lack of accurate and available data on the situation with children in the context of migration. Next slide, please. Since the topic is about standard setting, I put here the list of relevant existing human rights standards in ASEAN South Asia on the chronological basis, starting from the most recent one. And the most recent, which is actually quite relevant to the topic that we are talking today, is ASEAN Declaration on the Rights of Children in the Context of Migration. And this was adopted in 2019. Recently, just last November, ASEAN has adopted Regional Plan of Action for the implementation of Declaration on the Rights of Children in the Context of Migration. In addition to this Declaration and Plan of Action, ASEAN also adopted ASEAN Consensus on the Protection and Promotion of the Rights of Migrant Workers, including children, of course, and the ASEAN Declaration on Strengthening Education of Out-of-School Children and Youth. Of course, among migrant children, you have many of them who are out of school, especially in the case of Malaysia. We are in ASEAN. You also have Declaration on Elimination of Violence Against Women and Elimination of Violence Against Children, which was adopted in 2013, and the ASEAN Regional Plan of Action on Elimination of Violence Against Children, adopted in 2015. The only legally binding document in ASEAN is the ASEAN Convention Against Trafficking in Persons, especially women and children. Unfortunately, this ASEAN Convention Against Trafficking in Persons, especially women and children, does not include communication procedure. We'll be talking about this later, but just want to mention that, a word on this. And of course, the ASEAN Human Rights Declaration and the Phnom Penh Statement on the adoption of ASEAN Human Rights Declaration. The ASEAN Human Rights Declaration also mentioned the protection of the rights of marginalized groups, including migrant workers, women, and children. So these are a standard already set at ASEAN level. And as I mentioned that out of these relevant existing human rights standards, you have only one which is legally binding. The just want to go over briefly about declaration and plan of action on the protection of children in the context of migration or children on the move. A few things which I found quite interesting. First of all, the definition of who are children in the context of migration. In the plan of action, children in the context of migration is actually defined as children moving or who have moved for a variety of reasons, voluntary or involuntary, within or between countries, with or without their parents or other primary caregivers. And it also refers to children who were born to migrant parents in countries of destination, or children remaining in the country of origin after one or both parents have migrated. So you can see that the definition of children in context of migration is quite broad. It also covers children who were left behind in the countries of origin when their parents or one of their parents have moved to another country. Another interesting thing that I found in this plan of action, declaration and plan of action, is actually about, first of all, the direct declaration and plan of action ensure that children's rights contained in the conventions and the rights of the child can be fully enjoyed by all children in the region, including those on the move. So the CRC has been used as actually the basis for standard setting. The second one, adherence to CRC principles, especially the principle of the best interest of child. And third, the regional plan of action is a 10-year plan. And it covers 5 focus areas, including access to child protection services, access to other basic services, such as education, health, and justice, capacity development of the key actors, evidence generation, including research, of course, and partnerships in implementing the declaration, especially networking. So these are just some of the content of the declaration and plan of action. Next slide, please. Next slide, please. I just want to discuss here about the regional trends in standard setting. As I already mentioned by elaborating a bit on the by elaborating on the declaration and plan of action, that the trends in standard setting in ASEAN and South Asia is actually in some way influenced by external actors. So recognition of global and regional efforts, especially as I mentioned, recognition of CRC, recognition of the works of the CRC committee, and recognition of other regional mechanism. The second trends that we see here in the region is actually ASEAN has been showing international commitments by making reference to SDG, especially SDG, for example, 16 or global compacts. When we talk about global compacts here, I'm referring to the global compacts on migration and global compacts on refugees. However, as I have already shown in my previous slide, that in ASEAN member states, as an association, ASEAN member states and ASEAN as an association, usually opt for non-legally binding documents. I was emphasizing by showing you the list of standards already exists in ASEAN, that only one of them has a legally binding uh, power. The rest are all declarations and plan of action. And even with a legally binding document, there is no communication procedures included in that particular convention. Another thing that we see as a trend in standard setting in ASEAN is actually adhering to regional working principles. What are regional working principles? The regional working principles include, first of all, respect for state sovereignty and non-interference principle. Secondly, is about consultation and consensus. For ASEAN to do something, to do anything, it needs a consensus. Even if one country says no to, could you go back to the previous slide, please? Could you go back to previous slide, please? Thank you. Yes, I was talking about working principle of ASEAN. So cooperation, consultation, and consensus. I was mentioning that even one country say no, nothing can move in ASEAN. The third principle is actually cooperation and non-confrontation. What does it mean by non-confrontation? It means that um, countries, members of ASEAN, will not be criticizing or asking any question to each other. So these are working principles in ASEAN. Another trend that we see in ASEAN is that, although specifically addressing children on the move, like the declaration that I just mentioned, but remaining at the general protection with exception of the few areas. I just want to mention, I already mentioned that declaration also include, for example, the element of alternative to detention. But again, since declaration is not a legally binding document, there is no mechanism to addressing human rights violations. And there is no custody. Actually, the custody of the declaration is ministries which are not, independent bodies. I have discussed with the ACWC, ASEAN Commission on the Promotion and Protection of the Rights of Children and Women, and was interviewing them about whether or not within ASEAN, especially in the ASEAN Commission on Children and Women, whether or not they have been discussing about creating, any avenues for redress for individuals whose rights have been violated without domestic remedies, meaning individual complaints. The answer was quite categorical, no. ASEAN and the two commissions have never discussed about establishing any redress mechanism for victims of human rights violations, including children and children on the move. Another trend that we see in standard setting in ASEAN is actually the emphasis on strengthening of the national system and spirit of regional cooperation. What does it mean by strengthening of national system? It means, and I just want to mention, to emphasize that the optional protocol 3 itself actually requires for exhaustion of domestic remedies, which actually, allow, in this case, Thailand, to rely on the national system only. And I just talked with the Thai representative to ACWC, and he actually confirmed that because Thailand is so confident in the internal protection system of children. So Thailand was actually willing to ratify the optional protocol 3. So strengthening of national system is a key within ASEAN. It's not about looking at regional or international human rights system in including the CSC committee. And as I already mentioned, that one of the working principles of ASEAN is about cooperation, no confrontation. So ASEAN has been emphasizing on the spirit of regional cooperation. By regional cooperation, it doesn't necessarily mean that the cooperation would be conducive to the protection of children on the move, unfortunately. Next slide, please. Next slide, please. Yeah, I'm almost finishing my presentation. Ramifications. I am using a few analytical framework here. I guess when we talk about standard setting or norm setting, we are talking about substance, we are talking about structure, and we are also talking about cultural aspects. As I already mentioned, the substance of relevant standards which already exist in ASEAN, although adhering to CRC, although covering, a rise of children on the move, but it does not cover anything which would actually allow children on the move to access to justice. In terms of structure, if we look at the institutions that I will be talking later, if we look at existing institutions, regional institutions within ASEAN, we realize that the two commissions do not have any power to receive any complaints. And of course, we have to look at the cultural aspects of ASEAN when it comes to human rights, when it comes to children. I think there are many writings about cultural aspect of the perceptions of human rights, including child rights in ASEAN as well. So the effects or ramifications of standard setting in ASEAN South Asia are actually subject to three aspects here. And I'm using three aspects to assess the norm setting in ASEAN, which includes the capturing add values. My question here is whether or not the existing standard in ASEAN, especially the declaration on the protection on the rights of children in context of migration, whether or not that particular declaration or ASEAN Human Rights Declaration actually add values to what is in existence at the international level. In my opinion, I am not quite sure if it adds value to anything because, as I said, it does not provide any redress mechanism. It does not provide any avenue for the children on the move to access to justice. The second framework that I'm using here is by looking at effectiveness of human rights institutions within ASEAN. As I already mentioned to you that within ASEAN, there are two commissions. One is the ASEAN Intergovernmental Commission on Human Rights, the AICHA, in which I was serving for a bit over 3 years as a Thai representative, and the ASEAN Commission on Promotion and Protection of the Rights of Women and Children. The two regional institutions, as I mentioned, carry with it, a serious weaknesses, especially in the context of providing mechanism for redress, because the two commissions are not empowered to receive any complaints or to receive any communications. from ASEAN peoples, including children on the move. So in terms of, in terms of redress, in terms of communications, of course, the two commissions are not very effective. And as I mentioned, it's very weak. The third one is conducive conditions for engagement of stakeholders. Although ASEAN has presented itself as the ASEAN People Center, so an organization with people at the center, but engagement with stakeholders, including human rights NGOs, child rights NGOs, academic institutions, is not that active. So, and the conditions for engagement has not been built so far. Although in ASEAN you may be seeing a lot of child rights NGOs, but unfortunately, NGOs, child rights NGOs or human rights NGOs in the region are not really able to engage in the standard setting, including, pushing for effective human rights institutions in ASEAN. Next slide, please. Next slide, please. Next slide, please. Could you move to next slide, please? Yes, I'm concluding with some observations here. I see an interplay between domestic demands and external influence when it comes to standard setting trends and ramifications in ASEAN. On domestic demands, actually the ASEAN Charter, especially the purposes and principles, have also included promotion and protection of human rights and fundamental freedoms, including the rights of children, of course. Another, domestic demands lies on the fact that all ASEAN member states have already ratified, CRC, and I said all ASEAN member states have ratified CRC. Another domestic demands, of course, is actually the presence of children on the move for migrant children in the region. So you see, some domestic demands for the standard setting. However, those demands are counterbalanced by the ASEAN principles. As I mentioned earlier, that ASEAN has been working on three principles, especially respect for state sovereignty and non-interference. And of course, whatever happened in any country, especially when it comes to human rights issues are considered internal affairs of ASEAN member states. Regional organizations, regional institutions, including human rights institutions, do not have power to look into it. And as I already mentioned, that Thailand is the only party to Optional Protocol 3 in ASEAN. And as I alluded earlier, that the redress of human rights violation is still available exclusively to state because of the ASEAN principle and of course, UN human rights mechanism. I have checked the record whether or not any ASEAN member states have used, the international human rights mechanism, especially the CRC committee, especially, in the case of Thailand, which has ratified optional protocol. There has been no case from Thailand going to CRC, despite the fact that Thailand is party to optional protocol 3. So claims of individuals at the regional space remain contested. It's not only remain contested, but as I mentioned earlier, that ASEAN human rights institutions do not have power to address any complaints. And I mentioned in my previous slide that although CRC is widely ratified and fully ratified by ASEAN member states, but only Thailand is actually party to Optional Protocol 3. Next slide, please, which is my last one. Um, um, actually, I quote Dina Shelton, who was commissioner at the Inter-American Human Rights Commission, and I understand that he was chairing the commission as well. Professor Dina Shelton has mentioned that as the system have evolved, the universal framework within which they began, together with their own interactions, have had surprisingly strong influence, leading to converging norms and procedures in an overarching, interdependent, and dynamic system. In many respects, they are thinking globally and acting regionally. Each uses the jurisprudence of other systems and amends and strengthens its procedures with reference to experience of the others. In general, their mutual influence is highly progressive, but both in normative development. I agree with this particular statement made by Dina Shelton, especially using the case of ASEAN to study. As I was already analyzing earlier, that in ASEAN, although in some way ASEAN member states have been influenced by external factors, including CRC, unfortunately, it doesn't change the way the norm has been setting within the region, because we are still upholding, the importance of the primacy of the state and the state sovereignty. Nicolás, I finished my presentation. Thank you very much, and I would be happy to accommodate any questions. Thank you.
Thank you very much for this comprehensive presentation regarding the standards developed in the ASEAN region. You also touch on some challenges in trying to bridge the gap between the regional standards and the effective implementation of such standards on a domestic level. And as you said, regarding Dina Shelton's quotation, that the regional spaces be seen as spaces that measure interdependence, but that could support the implementation of local mechanisms or national mechanisms for protection to the rights of children. I'm sure there will be some questions, so I invite viewers to submit questions in the chat box, and we'll open the microphone at the end of the session. Now I will share the presentation of Pablo Ceriani. As I explained in the beginning, Pablo has recorded a video and he sent us his PowerPoint. He has Wi-Fi connection issues, so I'll be sharing his presentation. In case you see Pablo's presentation but you see me, don't worry, Pablo is way more handsome than I am. Shouldn't be any problem. I'm going to share my screen now and the audio of Pablo's presentation. Just give me 1 second, please. Just give me, please, a couple of minutes. I am trying to display the presentation, so just give me a couple of minutes. I'm going to share the audio and the screen. So first of all, I wanted to say thank you for the invite to participate in this session. Thanks to the Constitutional Study Center of the Supreme Court of Justice of Mexico. Second of all, I wanted to convey my apologies because I was unable to connect live for this activity to establish this conversation with you in order to exchange opinions after the two presentations that you will hear. Regrettably, I am in a zone in the Andean mountain range with limited Wi-Fi access. So it's impossible for me to establish a good connection for a meeting of this importance. This is why I have recorded this video so that regardless of my technical problems, to stay connected into this activity. So my presentation is about an analysis, a superficial analysis about many cases resolved in the context of the optional protocol to the Convention on the Rights of the Child in cases related to cases of children in mobility. As introductory notes on this topic and on the challenges for the protection of children on immigration, before jumping into specific cases, I wanted to make some introductions. First of all, we are in a scenario characterized by a quantitative and qualitative situation for children in immigration context and in conditions of vulnerability. And this is for different reasons. First of all, for the causes that generate the mobility of these persons and the conditions in which they can do so. They are people that live in conditions of vulnerability in their countries of origin. On the other hand, their lack of regular ways for boys, girls, or families to be able to transit among countries and reach other countries. There are growing restrictions for the exiting and entry, and also for the strengthening of our response before the immigration irregularity. And this is a structural problem because there is a lack of regular mechanisms and people need to exit in an irregular manner. So there's a biased environment measuring immigration as an action that needs to be sanctioned. So there is an increase in the number of boys and girls migrating, but there is a qualitative change. They do it in a more risky and vulnerable way. And also, there are many cases children are unaccompanied or they are accompanied by persons who are not their tutors or parents. Children may be accompanied by their caregivers. I'm thinking in children in context of mobility, but not in the context of persons trafficking. Another challenge is the limited perspective on the rights of the child and immigration, including, of course, and this is possibly the heart of the work of the committee for the communications that have been presented in the procedures, administrative procedures, judicial, immigration, and asylum procedures. The focus on children is so weak or non-existent in many cases. The focus on the rights of the children based on the articles of the convention. Connected to these, there are some opacity in the procedures, allowing to compel legal decisions, and this revolves into the presentation of international mechanisms or communications, such as the committee. So it is in this context where these mechanisms or procedures derived from international law of human rights becomes more and more relevant. This is why in the last decades, we have observed a progressive development step by step of standards on a regional basis, for example, by the Inter-American Court on Human Rights and on its opinion 21 in January 2014, and in some topics, and today in other topics of rights in the context of mobilities by the European Tribunal on Human Rights. But also, and we are talking about this by universal mechanisms such as the Committee of Rights to the Children, observations 6, 22, and 23, this along with the Committee for the Protection of Workers' Rights and their families. And of course, the effects of these challenges are seen in the increase in the number of cases or communications presented before the committee based on the optional protocol number 3. So what are the topics I am going to mention along this analysis regarding the decisions of the committee? First, cases linked to the age, immigration policies and their impact on rights. What rights are analyzed by the committee in this type of cases in a greater or lesser extent, and then additional notes in terms of guarantees to the right of being heard to based on Article 12 of the Convention, going through an analysis on a set of rights at play in the different cases submitted to the committee based on different types of immigration procedures or asylum procedures. Finally, I will mention one recent case on a right to education for children in irregular immigration situation and compensation ordered by the committee or redress, and final comments. As you know, a big part of the cases presented before the committee have to do with communications against Spain linked to a set of rights that have been affected in relation to the procedure for determination of age for unaccompanied children that Spain applies on its borders, on its south border, especially in 2017 and on. Too many cases have occurred or many communications have been presented to the committee. In these decisions, the committee, on the one hand, in relation to the determination of age, this is one of the aspects pointed by the committee, and it's the relevance of this procedure applied by Spain and other countries. It's not all the countries, not all regions applying these procedures. So this is important to underline, but what the committee says, this procedure is important because the result of this procedure leads into the application or not in the application of the articles of the convention and into the legal protection to children. So this is why these procedures are relevant, the set of standards to be met. The committee then questions the methods of the determination of age by Spain because it's an invasive process. In one of the communications, questions this abusive, invasive character of the method, the genital evaluation of boys and girls in persons recognized as underage, and concretely they do it in the case of an unaccompanied girl seeking asylum, arguing she has been a victim of sexual abuse. By the way, Alejandro Mora wrote about this, but the committee did not a very deep analysis regarding this situation in particular. Another aspect is the duty of the countries to perform comprehensive analysis in cases that determine the age. So these invasive methods should not be used, biased methods, because they have a lot of error margin. A set of interviews have to be carried out to boys and girls, psychological analysis, among others, so that we can reach a result. We need a more appropriate process. Another issue is the benefit of the doubt before the documents presented by children. The states question, if the states question the documents, they have to prove the documents are false, if that is the case. Another question regarding the determination of age, and especially with the decisions of the CRC, substantive decisions, and that's that basically the violations to the rights of the convention according to the CRC in this case, or in all of these cases, are determined by the combination of violation to Article 13, the higher interest of children, and Article 2, the right to participate, the guarantees of due process, pointing out the lack of a tutor or of a legal representative. And since the lack of guarantees, concretely the right to be heard, has to do with the violation to that right and the omission from the state to consider the higher interest of the children in the framework of the procedures. This is a general character, and the center of the analysis of the CRC in these cases is this interplay between these two articles. But then to some extent, and this is a punctual case, it analyzes some of the rights affected as a consequence of violating these two articles. Two articles that CRC analyzes in this case is Article 8, the right to identity, because the deficiencies in the procedures sometimes produce misleading information regarding the identity of the children. Article 20, it establishes the duty of the state to grant specific protection to children separated from their families, and that specific protection is not met because they are declared adults as a consequence of this procedure. Children are not channelized to the system of protection to families and children. In some cases, specifically, the CRC evaluates that the right to seek asylum has been violated, Article 22 of the Convention. I will mention it later on, but basically what the CRC mentions is that if they could not, as a consequence of the determination of the age, to seek asylum as children with the guarantees appropriate to their age. And it also mentions violation to Article 6 of the protocol because it does not meet some provisional measures linked to the detention of children. In these cases, the CRC questions the position of the state, and it says we cannot send persons over 18 years old to detention centers for minors because that is more serious for a children to be detained in a center oriented to persons over 18 years old. Closing the analysis of these cases connected to the procedure of determination of age, something I want to point out beyond all positive aspects of analysis done by the committee in these cases, it's in that sadly no contamos con audio en cabina. No contamos con audio en cabina. No audio. We are having an issue, a problem with the audio feed. We are unable to listen to Pablo's audio, but we are seeing the presentation though. Something happened with the audio feed. So what I can do is to, and this is the slide on the screen, right? So I can share the rest of the presentation so you can follow it. We are so sorry for this inconvenience. But these are the challenges of Zoom presentations. I don't know why the audio feed stopped. We are so sorry, but I would not like to continue only with the PowerPoint on the screen. So what we are going to do, because there are a lot of slides to run, so I'm going to share with you in the chat the PowerPoint from Dr. Ceriani, so you may want to download it, go over it, and to finish going over over his presentation. So I am so sorry for this inconvenience, because the truth of the matter, I don't know why the audio feed is not working as it should. So in 1 minute, you will get the presentation. And before that, regarding some comments we have received in the chat box, I would like to share with you, I would like to share with Dr. Sriprapha some reflections about her presentation. I would like to take advantage of the fact that the Professor Sriprapha is connected here. So what I wanted to ask you, Sriprapha, is that it seems, it gives the impression that there exists a gap, a distance globally between the innovative Asean standards in some fields like restorative justice, and that is something that we like when we over documents and standards in the region. But it seems there is a distance, it seems there is a material gap between the standards and the practice, and the local practice or domestic practice when it comes to an effective protection of the rights of children in the region. So I wanted to ask you, if does it exist, in your opinion, challenges? What are the challenges for the civil organization, for NGOs domestically that are demanding access to justice, to tribunals, to redress and to claim the implementation of these standards in the context of immigration? For example, in Latin America, in Europe, in the United States, we know jurisprudence that tribunals produce in order to force governments to prevent practices of detention, of family separation, of deportation. So there is a difference, so to speak, between the practice and the standards. So I wanted to ask you, in your region, can you tell us about interesting practices that push local governments in order to demand that all these standards be met?
Thank you for the question. I'm not quite sure if the question is from Nicolás or from the audience, but I look at the Q&A box and I see one question in English. So maybe before I address the question that you just brought up, I would like to address the question in Q&A and then going to, the question of gaps in implementation that you just asked. A question from Sarah Lembrecht. Sarah was asking what I think children in immigration on the move need more socially in order to be able to access to procedures under Optional Protocol 3 in Thailand. You think the lack of complaints until today is related to lack of awareness or other issues at stake, in my opinion? I think by addressing this question, I would be able to address the question of gaps as well. So what do I think children on the move need more socially in order to be able to access to procedures under Optional Protocol 3 in Thailand? I think what migrant children need most is, first of all, knowing, the existing mechanism, not only in Thailand, but at international level. As you know that maybe, about almost half of migrants in Thailand are in a regular situation. So, undocumented migrants, including children, are already facing a lot of challenges in accessing other services, not only in actually getting redress or accessing to justice. So what they urgently need, I guess in order to access to the procedures is first of all, regularization of their status. This is the first thing. The second thing, which actually help them to be recognized by Thai law. The second thing is actually awareness raising, that I think not only children, migrant children, but also their parents, or even, the Thai children. I'm not talking about children on the move here. I'm not talking about migrant children. I'm talking about Thai children. Even the Thai children are not aware of the fact that Thailand has ratified Optional Protocol 3. So you just imagine whether or not, the migrant children would know. Most, if not all of them, would not know. So the most urgent need is actually for them to know more about the procedures, about existing procedures, and about the procedures in Thailand. The third thing that they need to know is that in order for them to make use of Optional Protocol 3 that Thailand is party to, they will have to exhaust, to finish or to complete domestic remedies. And already accessing to domestic remedies is not really always available. And as I mentioned in my presentation, that Thailand tend to believe that their protection mechanism, national protection mechanism, is a good one, and they say it is available to all, but it's not always the case. So these are something that they need to know. And of course, the last, not last, but at least what I can think of is actually because everything will be done in Thai. At least, in the case of, in order to go through the national process, everything is done in Thai. So access to Thai education is the key for migrant children to know about this optional protocol and to know about their rights. The second question, do I think the lack of complaints until today is related to lack of awareness? Yes, definitely. Not only among migrant workers, among migrant children, but among lawyers or even child rights NGOs. I talked to the Thai representative to ACWC, and I was asking if actually dissemination of information about Thailand's ratification of optional protocol 3 is good or not. The answer was actually it was not good at all. So not only among lawyers, not only among representatives, but even child rights NGOs in Thailand, only a few of them would know about existing mechanism. Um, um, whether or not there are other issues at stake, in my opinion, yes, I think there are two other issues which are at stake, in my opinion. First of all, I already mentioned about irregular status of migrants, including parents and migrant children. And this irregularity and not only put them in a marginalized situation, but actually prevent them from accessing to justice at both national and international level. That's the first thing. The second thing, which I think is also quite crucial in the case of Thailand, since Thailand is the only party to Optional Protocol 3, is actually, about, and I want to emphasize here that because Thailand believes in the national mechanism and then one of the problem with for children to make use of this optional protocol, not only non-citizen but also citizen, is actually about having to exhaust domestic remedies. If you look at the cases which have already, reviewed by the CRC committee, you might notice that about 40 to 50% of them are not admissible. So, the question of admissibility by the CRC committee is actually issued that I think is crucial for accessing to the mechanism under optional protocol 3. In terms of gaps in implementation that Nicolás has asked, in general, there's a huge gap between ratification and implementation at national level already. And I'm not just talking about optional protocol 3, which is about complaint mechanism, but the gaps, general gaps is already there. But in the case of optional protocol 3, I think I mentioned all challenges that I think are crucial. And actually those challenges which prevent migrant children to accessing to making use of optional protocol 3 are actually strengthening the existing gaps between the ratification and actual implementation already. The second gap that I see, that there is no bridge. I think Nicolás has mentioned, or someone has mentioned about the bridge. There is no bridge between national and international level. As I already mentioned in my presentation, that the existing human rights institutions, existing human rights mechanism within ASEAN do not receive or do not accommodate, do not entertain any communications, any complaints. They do not have power to actually to investigate any human rights violations. And the lack of regional bridge, especially the ineffectiveness of regional human rights system within ASEAN, actually, make the gaps even larger. Thank you.
So thank you very much. Let's see if we are able to share a link in the chat. We want to share different Asian documents, and there are different sources mentioned in the presentation. It's going to help us have more context for the Asian region. There are too many sources as well, too many sources of information. So there is this overwhelming amount of information to some extent. And if you are following here, I have shared two elements. First, Pablo Ceriani's presentation, the presentation that I was playing so that you can complete it. And there's another link, and it'll give you access to a publication regarding a couple of questions asked in the chat regarding the particular case of Mexico. Because anyway, this is a seminar in order to discuss on a global basis, not only for Mexico, but there were a couple of questions in the chat. So I'm sharing the PowerPoint presentation and the link to a book recently published on access to justice and protection of children in the context of international mobility. I'm asking Gabi or Diana to enable the chat so that everyone will have the link. The link should be shared with everyone. So Diana or Gabriela, can you help us? So this is the PowerPoint, and there is a link to a publication. So you'll have the links. And regarding this question on Mexico, I wanted to mention that there are a number of different things. First of all, Mexico has not ratified the optional protocol 3, the OP3. And this means that when the domestic protection fails in Mexico, there is no possibility for immigrant children, for asylum seekers, for unaccompanied children to have access to the CRC. They could do it before the Inter-American Commission on Human Rights or before other United Nations mechanisms that allow collective or individual reports. But today, immigrant children in Mexico who don't have legal protection, they don't have access to the CRC. So I would say that one of the very first things to be done is to build awareness on the need for the Mexican government to ratify the OP3 in order for children to access the CRC, not as Sriprapha was saying, not to replace the need to strengthen domestic mechanisms of protection, but to leave a control space internationally when the domestic mechanisms aren't enough. In second place, I'd say along with mechanisms that have been adopted, and in the book I'm sharing at this moment, you'll see there is a specific chapter on Mexico regarding different things that have been consolidated in the comprehensive system for protection of children. In my opinion, one of the most important flaws in the region has to do with the access to mechanisms of reports before the administrative and the legal authorities when the authority has not respected the rights of immigrant children. So in this regard, strengthening mechanisms of access to children in context of international mobility is of the essence. And that means tutelage and training and overall, children don't have information regarding these mechanisms for accessing justice, especially children in mobility. In the book, you learn about experiences in the North America, in Europe, where different strategies of litigation have been put in place to force internal tribunals to implement these mechanisms. Sriprapha has also shared the Asean website, where you will find references to treaties, declarations, and different mechanisms created in the region for this topic in particular. I don't see further questions in the chat for Sriprapha from the participants, and we are almost in the top of the hour, so I would like to thank you. Thank you so much for connecting. I'm so sorry for the technical difficulties. Sriprapha, thank you so much for your patience. We are always trying to do our best to move forward, but you know, we have these technology challenges, so hopefully they won't repeat. So thank you so much, Sriprapha, for your time, for your excellent presentation. And I would like to invite all participants to go over the experiences on the Asian region. Many times we discuss more on whatever is done in Latin America or Europe, but we need to immerse more in the Asian context. They have challenges, but they have made very good progress. In Thailand, in particular, has played such an important role globally on this matter. So I encourage you to also access to the presentation. And before letting Sriprapha go, I would like to invite you to the next presentation. That's going to be on February 17th, Thursday, and this is the role of children in access to justice, the OP3 as an empowering tool for boys and girls, so that it is them who will demand their rights. And will have the participation of Professor Aoife Nolan from the University of Nottingham, United Kingdom, and Ms. Karabo Osa, Deputy Director, Center for Child Law from South Africa. So thank you so much. Stay safe, stay away from Omicron, and follow recommendations, and see you on February 17th. Sriprapha, thank you so much for such a great presentation, and thank you for joining us today.
Thank you so much, and good night, good evening. Thank you. Bye.